All right, if everybody would take their seats, I'm going to get us started. I think this is usually one of the most popular panels of the day because this is where most people have a lot of questions and you don't often get an opportunity for a free consultation with an attorney. So we're going to pick their brains a little bit and have this opportunity to chat and for them to tell us a little bit about their work and their cases and what they've been doing and some of the advice that they would have. So I always start with Tom Devine because as I like to refer you as the guru of whistleblower law. Tom is also our resident expert on the federal whistleblowers and federal whistleblower laws in the system. So if we can pass you a microphone or we can share some of them. Yep. Yep. All right. Tom Devine from the Government Accountability Project.
Thanks, Jackie. And what I'm going to do is kind of give an overview of the challenges that our movement is facing and the opportunities. And, you know, from reading A Tale of Two Cities, I think it's the opposite. It's the worst of times, but it could be the opportunity for the best of times. And so I think we have a lot of work to do, but it's a good energy after good. Let's start with the bad news. The bad news is that the current administration, the Trump administration, is trying basically to demolish the administrative remedies that enforce the Whistleblower Protection Act. It's a multi-pronged attack on the merit system rights that have basically governed the federal labor force since 1883. But the president wants to turn the federal labor force into a patronage operation, which basically would be a spoils system, that his campaign workers would get the federal jobs, and their primary duty would be re-election of the party in power rather than service to the public. And this is something we just can't accept in our country. There was a precedent for this with President Nixon in something called the Malek Manual. That Malek Manual was a secret operation to get rid of the civil service, and it was one of the main issues for his potential impeachment in the Watergate hearings. But what President Nixon tried to do in secret, President Trump is doing openly through something that he called Schedule F at the end of his first term. It's now Schedule PC, Policy Career. The idea for this is to remove conservatively about 80% of the federal workforce from the merit system and call them political appointees, or a new category of political appointees. That means almost everyone. And I think a little history lesson when President Nixon tried to do this is useful. The Malek Manual implementation was to make a political rating system for every employee in the government. 1 to 5. 5, you're untouchable. 1 is you're untouchable. 5, you can have fun when you get rid of them. And a political rating system for every applicant, so that a major donor or powerful figure get any job they wanted. Just get rid of whoever is there. Down to a 5 that you could have fun when you turn them down. And they went through and had a political hiring czar for every agency in the government. It was camouflaged in their management titles, but that was their duties. And this was exposed and it was stopped, but Schedule CP is like deja vu. The idea is that you wouldn't have access to the Office of Special Counsel. You wouldn't have access to the Merit Systems Protection Board. The administration has said that this is only going to affect about 50,000 people, and they'll still have their rights. But if you look at the definitions, almost anyone who's involved in public service is covered by Schedule PC. But the only people who aren't are maintenance workers, food service workers, people like that. But if you're serving the public, you're a political appointee. For those people, yeah, they've still got their rights. They're not canceling the Whistleblower Protection Act, but they're saying it'll now be enforced by the agency where you work, which means the same institution that has always been, for 46 years, it's been the defendant in retaliation cases, will now be the judge and the jury of its own alleged misconduct. In other words, the rights under the Whistleblower Protection Act will be a bad joke. That we're challenging this in court. GAP's a plaintiff in a lawsuit to challenge this proposed regulation. But with the decisions that have been coming up in the Supreme Court, I'm not optimistic. That's one attack on the merit system. But they're not stopping there. Another one is setting up gag orders against any unauthorized disclosure that will be enforced through leaks investigations and polygraph examinations. This is completely illegal. And Senator Grassley, who's the champion and sponsor of the anti-gag laws for the Whistleblower Protection Act, is pledged to help us fight back against this. And even the new special counsel has said that they'll enforce the anti-gag statutes. But they're happening and they're out there. The third attack is suitability investigations. Before anybody gets hired for the federal government, they go through a suitability investigation and make sure that they're credible and trustworthy. This is for applicants. Now they're going to be having suitability investigations for all the incumbents. And the issues for the suitability investigation is whether or not you've signed and are committed to a loyalty oath to the current political party that's in power. This is another way to purge federal employees because suitability checks are not covered by the Civil Service Reform Act. They're outside of the merit system's protections. And then the fourth attack is ending the political independence of the agencies that enforce, administrative agencies that enforce merit system rights. If you get through all the gauntlet of loopholes and, not welcome signs and still have a case, the Merit Systems Protection Board can't even act on it because they don't have a quorum. There's only one member of the Merit Systems Protection Board. The Supreme Court blocked the temporary reinstatement of the only Democrat, the chair of the Merit Systems Protection Board. It's an all-Republican, one-person operation that's paralyzed. The last time this happened, we ended up with a backlog of 3,500 cases. And that could happen again. You can't count on those rights. Or what about the Office of Special Counsel? Well, the president has nominated a gentleman who, as a teenager, led a neo-Nazi youth party, is an extreme right-wing podcaster who wants to make January 6th a national holiday. And he'll be in charge of protecting freedom of speech for those challenging the Trump administration. Trojan horse. The final thing that's an attack, the fifth angle that's attacking the merit system, is canceling the collective bargaining agreements for the unions, federal employees' unions. Those collective bargaining agreements through arbitration have had the most effective way to enforce your Whistleblower Protection Act rights. The arbitrators are much, much more objective than the MSPB administrative judges. But there's not going to be any collective bargaining agreements anymore to trigger those arbitrations if the administration gets its way and wins the court challenges. Well, I know this sounds a little gloomy, but it's the facts of life. And, if we're sensitive to the nature of the assault, we can find ways to circumvent it. I was kind of a hippie as I was growing up, and it always impressed me that magic mushrooms came out of cow pies. and we can turn something that may be better than the current remedies. Use this as an opportunity. The Merit Systems Protection Board has never been truly politically independent. It's been false advertising. I've been doing this for over 4 decades, and Democratic presidents from Jimmy Carter to Bill Clinton to Barack Obama have ordered pro-whistleblower decisions to be reversed when they were going after politically sensitive people in the Democratic Party. It's not just the Republicans, it's whoever has the power. If the administrative agencies are an unavoidable institutional conflict of interest. My mentor, Ernie Fitzgerald, called the Civil Service Reform Act the Civil Service Deform Act because it moved access to court to enforce First Amendment rights. And as he told me, and it's been blazoned in my soul for decades, Tom, bureaucratic justice is no justice. And if bureaucratic remedies are being devastated, it creates an opportunity to fight for something better. And the gentleman who gave the speech this morning, Senator Grassley, his staff has pledged to work on legislation that will give federal employees the same rights that almost all corporate whistleblowers do. If their administrative remedies aren't providing timely relief, they can start fresh in federal court and seek justice from a jury, which would take the politics out of freedom of speech. My request and recommendation for everyone who's doing advocacy connected with this conference and in the future, get in touch with your congressmen and your senators and tell them if they support whistleblowers, give us access to court to seek justice from a jury instead of sending us to bureaucratic boards that are captured by whichever political party is in power. Federal employees are the only significant sector of the labor force that doesn't have access to court and jury trials to enforce their free speech rights. State and local employees can under the First Amendment, and almost the entire private sector is covered by corporate whistleblower laws that allow them to go to court if the administrative remedies aren't working. That's our challenge. That's our opportunity.
So I'm going to call on Dan to go next, if you don't mind, and then Cleveland, and then we also have Brian and Rob who will talk about their experience representing John Barnett and Boeing, against Boeing.
Hi, I'm Dan Meyer, and I count among my mentors Tom Devine. I started out in this business in 2000, basically, having been probably the least wealthy attorney in Washington pursuing communications law after the Communications Act. I was a miserable failure at that. And somebody said, Dan, you need to make money in Washington. We do that in the nonprofit sector. And I had no idea that nonprofit sector actually existed. So I went to work for Public Employees for Environmental Responsibility, which was run by Tom's good friend, Jeff Rook. And the first day I walked in the door, he was screaming on the phone at the editor of the Washington Times, the conservative paper, and he said, the next time you mention my name in your rag, you will say I'm left-wing, not left-leaning. And I thought, oh, wow, this is going to be really interesting. So on the security side, I wanted to take a step back and kind of connect it to Tom's thoughts with some words about federal employment law and the Merit Systems Protection Board. I've just completed 2 chapters for a treatise by Lexis. It's going to come out this year. It's already outdated. We finished the text in March, and I'm going to try to get a couple more paragraphs in. But having reviewed the whole story, and I started with the Jackson administration, the original spoils system, there's a couple of things that sort of resonated with me. One is that Tom's idea of all circuit litigation or all district court litigation, I think is very important because the failure of administrative tribunals, 2 of which I ran one for the intelligence community, I ran one for the Defense Department, is historic. Okay, even before the reforms of 1978, the old Civil Service Commission tried to set up something similar to MSPB, and it flopped. It flopped over almost a 40-year period. So there is just something wrong with management running a system which vindicates the rights of employees who are informing on management. I mean, this should not be a sort of aha moment. It just should be obvious to people that there's a tension there that has disserved us now through almost a century of trying to fix the problem. What I located, and I used to teach this in both the Defense Department and the intelligence community, it was not well received, this observation. If you compare Title V, the whistleblower protections for federal employees, with Title VII, our EEO laws. Our EEO laws in general work. They were passed, the standard was set, it was not adopted. Many people, particularly men in the federal government, had the wrong idea in their head for another 20 years. You had to have some really big cases where really important people were taken down internally in EEO cases. But by the early 80s into the 90s, in particular with the Clinton administration, people knew what was wrong in the workplace. And so it was making the EEO system work. The statute had been internalized as a behavioral standard. Compare that, and why did that happen? Because it made no difference how you did your job, what your race was, what your gender was, what your disability was, what your age was. None of the suspect categories had anything to do with how you did your job as a federal employee. That's why it succeeded. Now compare that to Title V. Why did Title V fail? After we passed the statute, 1978, we had some in 82 and 89, because the standard never went from the page, after Tom wrote it, Tom wrote most of those, to a standard in people's heads. And why did that happen? Because your role as a whistleblower directly implicates your boss's performance. Okay, you're informing on management, and so there's been this very visceral resistance to the idea of disclosure from the very beginning. I tried to sugarcoat it for admirals and generals and SESs and Secret Service officials and say this is about source protection, because I knew they were cops, and cops understand their sources. And so my job's always had that title, source protection, in it, and I gained some headway on that. And that would work for about 75% of the cases. And then in that 25, it was always when Charlie or Spivey or Jimmy was caught up in the investigation and somebody wanted to figure out a way to make this all go away so that their friend or somebody on their Rolodex wasn't touched. So there's an inherent tension there that you could resolve in a court if you have juries. But unless the bureaucratic system produces a solution, and I'm not going to produce it now, I don't think, after our 20-year high point, then that's going to be difficult to do bureaucratically. I think the high point of the current whistleblowing moment, sorry I'm saying this, Tom, was like 1992 with Hazel O'Leary's work in the Energy Department. I mean, there was a point where we were just sort of, and Hanford, I think, was the big project. We were just getting to the point where you could see in 1992 where there'd be a new age of whistleblowing. And then the rest of the 90s was just a disaster. We had politicization of whistleblowing. We had political scandals where whistleblowers were playing a role. And we rolled into 9/11. And I was hoping for the big Daniel Ellsberg moment during those wars, because I was in the Defense Department, I was running the program, and I said to myself, somewhere in all this stream of complaints, I'm going to find Daniel Ellsberg, and I'm going to protect Daniel Ellsberg. And what happened during the wars for the next 20 years? We got rid of contractor whistleblowing because we agreed with the contractors. As soon as there was a violation found in a contract, we would then ratify it. So by the time the whistleblower came forward, either the problem had been fixed or we had told the contractor it was okay. So we never had those big contractor whistleblower moments that we had in the 1970s with like submarines and aircraft, Ernie Fitzgerald's disclosure. There's a reason why Bonnettine Greenhouse settled her complaint with the federal government with an EEO case, because the whistleblower laws really weren't there to protect her. So what did happen? Completely unexpected, we had all the intelligence community whistleblowing because we had electronic surveillance going out everywhere. And I can remember the night. It was 10:30. I was asked to stay behind by my boss. A very senior official came in and he said to me, my boss said, we got to figure out something to do for this guy. And I looked at his name as I was going in the room, and I'm like, oh my God, he's a political appointee. He's presidential appointee, Senate confirmed. There's almost no protection for him. He's completely political. I listened to the disclosure back against the wall where the 15s all sat. The IG's up there. We hear the whole disclosure about what was going on. And the IG turned to me and said, Dan, what can we do for him? And I said, there's nothing we can do for him. He's a political appointment. This is just a mess. And then he looked at me and said, well, what should I do? And I said, right after this call, you get on the phone with the vice president. You drive over to Cheney's residence and you tell him everything. I figured, well, we might as well just go right to the top. And Cheney was the top. And the next day, find out that a package had gone up to the Hill to pass legislation and ratify what had happened at NSA and make all that was a violation of electronic monitoring, Tom Drake and all those O'Rourke and all those great whistleblowers, make it legal. Patriot Act came in and just blessed everybody, and we never had the Ellsberg moment. Those whistleblowers just were kind of abandoned by events as they went through. So on the security side, what it's left us with is we have a system where we got PPD-19 through. Tom and Danielle Bryan proposed it. I whispered in somebody's ear, they wrote it. National Security Council stepped in and stole it and cut everybody out of the debate. I think I got 45 minutes of coordination time on that document. Then I went to take over that program. So Mr. McCullough said, well, you got PPD-19 passed. Now I'm going to hire you and bring you in to run it. Got over there, and probably the best moment on security whistleblower law the last 2 decades, Tom and Danielle, and I think Angela Canterbury was involved in this, got statutory language passed without the CIA knowing it. I thought this was really interesting, that codified portions of PPD-19 and provided protections for whistleblowers in statutes, and some of those have been replicated for other security agencies. And my boss came running into my office and said, who the hell did this? I said, I didn't do it. I had nothing to do with it. And so that structure was in place, but it was all reliant on inspectors general, no jury trials. So 2017 rolls around, the current president, his first term, wanted to fire all the IGs. Michael Horowitz intervened, stopped it. There was no midnight massacre. They should have taken heed because it was going to come back. We went through the whole impeachment debate. Whistleblowers, everybody now thinking whistleblowers are, I think the nature of whistleblowing changed after impeachment. Benghazi was the start, but impeachment finished it. And then we end up with a situation where the president comes back, and what's one of the first things he did in January? Sopranoed the IGs. Streets were littered with IGs. You couldn't walk through Washington without a corpse of an IG somewhere. Now, some of those IGs, I did not shed a tear. Some of them had told me when I worked for them that they didn't like whistleblowers, they didn't like my program. There's one IG in particular who refused to leave her office, and the last time I'd seen her, she told me that whistleblowers weren't worth the effort. So when she got walked out, I said, well, there is justice. If I don't get it to a jury, it'll come elsewhere. But that was the central problem, is that entire security system based on reviewing security clearances as reprisal for whistleblowing is based on an IG system now, which is going to be reflexive. It's going to be in a fetal position for a generation. Okay, if you're an IG, the new IG coming in, you're not going to be from the old school, Michael Horowitz's school of IGs. That moment is past, and we are going into a new moment. And frankly, the ability to turn IGs as a force against workers, just like offices of professional responsibility, is very clear, and it's very doable. It can happen in a matter of weeks. So that's where we are on the security side of things. I think that's a pretty good summary. And then if anybody has questions later, I'd be glad to answer them.
Thank you, Dan. And I forgot to say that you're with the Tully Rinckey Law Firm. Yes. Here in Washington. All right, and over to Cleveland Lawrence from Mahaney Scalet. We've worked some cases together, so I'm excited to hear some updates from you.
It's great to be here. So yeah, I'm Cleveland Lawrence III. I'm a partner here in DC at the law firm Mahaney Scalet. My firm sort of started out, I guess, some 25 years ago as a civil rights firm doing a lot of race and gender discrimination sort of at the start of the DEI movement. And actually, our founding partner, Cyrus Mary, is one of the orchestrators of the Rooney Rule in the NFL to ensure some hiring parity and higher levels of football. We sort of recognized some time ago that, one of our basic civil rights is the right to be a whistleblower. And so the firm started a whistleblower practice. At that time, I had had a former career in big law where I first sort of saw whistleblowing from the defense side. After a little less than a decade doing that kind of stuff, I switched sides and sort of started working for a nonprofit organization that was called Taxpayers Against Fraud. It's now been rebranded as the Anti-Fraud Coalition, but still keeps that name TAF, T-A-F. And that's sort of a bar association for whistleblower lawyers. So I did a lot of law and policy work around whistleblowing, had an opportunity to testify before some state and federal congressional and legislative bodies, worked with states on draft legislation, lots of amicus briefs, all that kind of stuff, a lot of educational conferences and things like that. So eventually I decided to stop reporting on other people's cases and I took the plunge and went back into private practice about a decade ago to do this work myself. And, my firm sort of does the gamut of whistleblower cases. And so that generally starts with the primary whistleblower law, the False Claims Act, which is a law that allows anyone to sue essentially on behalf of and sometimes in partnership with the federal government, and about 25 states or so have some version of this that allow whistleblowers to sue on their behalf. Those cases are generally filed under seal to allow the government body some opportunity to investigate the whistleblower's claims in secret without tipping off the defendant that they're a target. And then the government generally has a decision to make. They can join the whistleblower's case. They can choose not to join, but allow the whistleblower to proceed on their behalf sort of without their official partnership, or they can decide that the case should be dismissed for one of many reasons. So that has been sort of the model whistleblower law for the last 40 so years in America. We borrowed the concept from way back in ancient Rome through the medieval times in England, and we adopted our law actually in the midst of the Civil War when the Union Army was being defrauded and cheated as it was trying to battle the Confederacy in the fog of war. So that's our main law, and my firm certainly does our share of those cases. That law has become sort of a model for several federal government agencies to have whistleblowers bring information to them. So I think we're approaching 10 now agencies, the IRS, SEC, CFTC, Department of Transportation, Department of Treasury, and most recently, we have a law called FIREA, that's a financial institutions law, and then more recently in the last year or so, Department of Justice has sort of taken control of two new whistleblower programs, one that generally goes after corporate crime that another program doesn't cover, and a very new law that was just announced a couple months ago that combats antitrust violations. So, those laws are similarly modeled after the False Claims Act. They don't require someone to file a lawsuit on behalf of the government. They just require someone to bring information, sometimes with counsel, sometimes not required to have counsel. If that information results in a significant monetary sanction, usually $1 million or more, then the whistleblower is entitled to a reward. Under the False Claims Act, whistleblowers whose cases are successful are entitled to a financial reward, generally speaking, between 15% and up to a maximum of 30% of whatever their case helps the government to recover. 15% is usually seen as sort of we call it a finder's fee, a floor. If the government joins the whistleblower's case, then their reward is usually capped at 25%. If the government chooses not to join the case and the whistleblower, who has to be represented by a lawyer to represent the government in these lawsuits, then 25% becomes their minimum, because they're going to bring all the resources to bear to get a settlement, and they can get up to a 30% reward. And in some of my cases that the government has intervened on, we were fortunate to get, near maximum relators rewards. I think 23.9% is the highest we've gotten in one of those, and we've gotten a 29% reward in a non-intervened case. So, there are opportunities for the government to embrace the concept of whistleblowing, and they certainly do when they have issues and targets that they want to pursue. And sometimes they update those, and sometimes those updates are encouraging. We've seen some updates that are less encouraging, certainly in the financial industry. I think crypto enforcement is probably where a lot of attention is going these days, aside from the more traditional healthcare and defense and procurement frauds. That can touch a lot of these programs. People use crypto to cheat on their taxes. There's a lot of discussion about whether crypto is a security or a commodity, and does SEC or CFTC have jurisdiction? Certainly the Department of Treasury is looking at money laundering issues and how crypto is used there. So I see that as being one of the burgeoning areas for the government to figure out how it's going to enforce and how it's going to use whistleblowers to do that. We learned very early in these processes that most whistleblowers are going to be insiders. They don't always have to be, of the company and people that they're blowing the whistle on, and they're going to experience retaliation. So a lot of my practice also involves sort of being an employment lawyer. And we've learned over the course of time that whistleblowers experience a lot of the same types of discrimination that our civil rights, gender and race discrimination, age discrimination, and disability discrimination. A lot of those people were suffering a lot of the same traumas that Jackie so eloquently documents for us. So I have to represent whistleblowers who have employment claims as well. And a lot of them don't even know that they have claims for rewards. They come in as employment clients looking to right or wrong that's happened against them when they were trying to do the right thing on the job. Sometimes those employees are public employees, and I call Tom, and we wrestle with how to deal with First Amendment issues and other issues with public employees. Sometimes they have security clearance and intelligence community issues, and I call Dan, and he helps me figure out how to represent some clients in those contexts. But overall, that's sort of the practice. We've sort of, started recognizing, especially with Jackie's expertise, that a lot of whistleblower retaliation clients suffer from these, invisible traumatic harms. And so Jackie, as she mentioned, has worked with us, to document and try to get compensation for those injuries. So I think that's also in sort of the retaliation realm. The burgeoning new area is figuring out how to categorize and document and receive adequate compensation for the non-monetary harms that whistleblowers often suffer, the mobbing and all the other things that Jackie talks about. So I don't want to step on anyone else's toes or take up too much time, but I'm happy to answer any questions about any of the laws or programs. Sure. Should I?
No.
Okay.
Let all the panelists complete so that we have time for questions, and I do have some questions I want to come back to, but I want to turn this over now to Rob Turkewitz, and I see we have Brian on screen. Oh, whatever.
Hey, good
Brian,
morning, Jackie.
we kick us off?
Good morning, Jackie. Can you hear me okay?
Yes.
Good. Good morning, everybody. So my name's Brian Knowles. I'm an attorney in Charleston, South Carolina. Rob and I actually practice and co-counsel on a lot of different cases together. We have separate law firms, but he and I have worked together for over a decade on different types of cases. And part of our work involves representing whistleblowers, including, which is a kind of a niche area, aviation whistleblowers. We represented the late John Barnett and also the late Josh Dean. And just as a little background, I'll give you an overview and then kind of get into some specifics. But under what's called Air 21, which is the sole remedy for an aviation whistleblower, if a person in the aviation manufacturing community, for example, is retaliated against, they have a very short statute of limitations of 90 days to file a complaint with OSHA. And then OSHA assigns an investigator who looks into the facts and allegations of what the whistleblower is complaining about and alleging, and the type of retaliation that they're alleging. And like in John's case, it took 4 years for the investigator to conclude that there was no retaliation. And at that point, that's when you can get your day in court, per se. And you file an appeal to the Office of Administrative Law Judges. And that's when you get a judge. It's not a jury, but that's the way the system works there. And Tom can tell you too, Rob and Tom and I have talked about attempting to amend the Air 21 statute to extend the statute of limitations. I mean, 90 days is a pretty ridiculous time period. You know, in South Carolina, you have 3 years to file a personal injury case if you're in a car wreck, for instance. Here you're dealing with folks that have been retaliated against. A lot of them have been terminated, and they're trying to care for their families. And the last thing they're thinking about is, well, do I have 90 days to file a complaint? What do I do? And, you know, another problem I'll say with this is I don't believe that the aviation employers are actually teaching their employees that this law even exists. From my understanding, there's no training on it, and that they don't have any posters at the work sites about it, informing their folks of their rights. And Boeing, for instance, likes to tout that it has a strict anti-retaliation policy in place. Well, you know, if that's true, I would think it's just kind of logical that you would want to train your employees all the way from the people on the floor through human resources up to the executive level that, hey, Air 21 exists, and it's illegal to retaliate in any fashion against your employees for raising, for instance, quality and safety concerns, like all of our aviation clients have done, including John. So John, we filed his appeal, and actually we filed the Air 21 in 2017. And then we ended up filing in 2021 to get into the Office of Administrative Law Court. And John had raised many serious quality issues while he was employed at the 787 plant in North Charleston. So John had worked for over 30 years at Boeing, had been out in the Washington State area working on the 777 program. He worked on, I think, about every program that Boeing had other than the military side. And then he was transferred down here around 2011 to help set up the quality side of the manufacturing on the new 787 Dreamliner program. And I will say too that everything that John alleged and that we talk about, Boeing completely denies. And they would deny anything that Rob and I say, which is fine. But, you know, we do our job and represent our clients and put forth what they claimed and try to get them justice and accountability from the companies. I'm not really going to get into a lot of the specifics on John's case. I mean, for instance, he alleged that there were hundreds of lost non-conforming parts, which means a non-conforming part, let me back up. A non-conforming part is a part, for instance, that a mechanic may have dinged up when they're trying to install it on the plane, and then they have to take it off and then take it to a certain area and get all this paperwork written up on it. It has to get engineering dispositions on whether it can be repaired and then reinstalled, or if it has to be scrapped and thrown away. And John had documented and complained internally and also filed a complaint with the FAA, which substantiated part of that complaint, that there were all these lost non-conforming parts. Which, I mean, again, logically, one would have to just infer from that. I mean, unless parts are being sold on the black market, I mean, where are these parts lost? I mean, they're airplane parts. And some of these were extremely large parts. So it's just disturbing allegation to know about. And John was really concerned about the safety of the flying public. He was concerned that these 787s were going to start crashing at some point due to the quality neglect and the quality violations that he was seeing and reporting. So I'll talk a little bit too about Josh Dean. So he was a younger guy, about 45. He worked at Spirit Aerosystems, which is a contractor to Boeing, and they make the 737 MAX, the fuselage, which is the round body of the aircraft. They manufacture that, the three sections together, and then they put it on a train, and it's shipped by rail from Wichita, Kansas to Renton, Washington, and then Boeing takes it and then installs everything into the aircraft and gets it ready for delivery. And this is the MAX again plane, same plane that the last year in January, the Alaska Air incident where the door plug blew out midair. Thankfully, nobody died on that, but that was a pretty horrific event in aviation. And Josh was a quality auditor. So his job was to go around and try to find why certain quality issues continuously were being repeated. And he would raise or investigate and conduct audits into certain repetitive quality issues and then generate reports and recommendations. And one moment. And Josh actually found and documented that there were all these misdrilled and misaligned holes when they were joining the sections of the aircraft together. He reported that internally and filed documentation. This is all public knowledge. And he had served as a witness in the Spirit shareholders securities case. But he had documented this issue about almost a year prior to Spirit and Boeing announcing it publicly. And this ended up being like a multi-billion dollar, not million, but $billion fix and problem for Boeing. It appears to us that Spirit shelved it. I'm not sure if they even told Boeing about it, and ultimately got rid of Josh a few months after he had reported it. Josh was really upset about that, and it really concerned him, again, about the safety of the airplane, knowing that there were these misdrilled and mislined holes that you do not want on an aircraft. It can cause a serious safety issue. And he had been very vocal, as John had been in the media, trying to get the word out about their fear and for the safety of the flying public. But change gears a little bit and go back to John. So John, we got into discovery and we had exchanged interrogatories, requests to produce. We started engaging in depositions and started the first deposition in his case, I think back around January of last year. And then John was scheduled to have his deposition in March of 24. And Boeing took his deposition all day on a Thursday, the 7th of March. Under the rules, you have 7 hours to question the witness. So, of course, we're not sitting there 7 hours straight. We had to take lunches. We took breaks. So, I mean, it turned into a pretty long day. It's like 9 hours. And then we needed to question him. So he had to come back the next day on that Friday. And we agreed, he was tired from Thursday, and we agreed for him to come in a little bit later on Friday. I ended up examining him for about 4 or 5 hours, just trying to get on the record his concerns, his allegations, the retaliation that he faced on a daily basis from individuals he alleged that were his superiors. And then I did not get finished, and there was a big argument with us and Boeing about how we were going to continue this or come back. And we ultimately agreed that we would come back Saturday, come back around 10. And then John was going to finish up. I only had maybe 2 or 3 hours left. And then he was going to drive back home to Louisiana. John, but that's another thing. John would not even fly anymore. So he would drive, and that was due to his concern for the safety of airplanes. So he would drive back and forth to Louisiana, come up to Charleston to help Rob and I work on his case together a lot. Well, unfortunately, Rob started calling John's phone that morning on Saturday, and it was just going to voicemail. And then Rob called me up and said, "Have you talked to John?" And I said, "No." And he told me, "Well, I keep calling him and it's going to voicemail." Now, remember that morning, it was raining like crazy here in Charleston. And some of y'all may have been down here, but if it rains really hard, it floods, particularly downtown Charleston, and that the roads get shut down. It becomes tough to navigate around downtown. And that's where the deposition was being held. And John was staying at a hotel right outside the main downtown part of Charleston. And it was flooding even over where I live. And I called John, and it went to voicemail. And then my wife, Martina, who's also my paralegal, and had been helping us out, prepping for the dep, helping me get ready for the deposition again, getting documents together. We're driving. We leave the house. We start driving to the deposition site. Martina said to tell Rob to call the hotel and do a wellness check. And Rob called, and they sent somebody to his room, and they said his stuff was there, but he wasn't in there. And then ultimately, we asked him to check for his truck because it was a distinct color. It was a Clemson orange truck color. And so ultimately, we find out that they told us that there was an incident with John. They couldn't get into details about it. And so we all went down to the Holiday Inn there and saw that there were ambulances there and police, and they had blocked off the area where his truck was. And we go inside and talk to the manager, who Rob had been talking to earlier, and she just approached us and said, "Sorry for your loss." So at that point, it was a state of shock. Fortunately, I've never lost a client before, and I'd never obviously had a client who was found in his truck with a gunshot wound to his head. Yeah, that was a tough day and a tough period of time after that. Not only as his lawyer, but I'd come to be friends with John. He was such a good guy. He was very honest and had a ton of integrity. He wasn't in it for the money, and he was trying to get some justice and accountability and get Boeing to get back on track. So a few, it wasn't about four weeks later, I was traveling. Martina and I were over in Germany for a conference. I chair a subcommittee for a working treaty group attempting to propose a new international tribunal called the International Anti-Corruption Court, which would hold kleptocrats accountable when their home jurisdictions would not. It would be based in The Hague, have general rules and guidelines, kind of like the International Criminal Court. And I would chair the subcommittee on whistleblowers and victim protection. And we were over there for a working group for a week to discuss our different sections of the treaty that we had been working on. And I get a call from Josh Dean's stepfather telling me that he had been airlifted from the local hospital in Wichita to Oklahoma City Hospital. And I said, "For what?" And he's like, "He's on life support. And he's got a lot of things going on with him. He's got gangrene on his feet and hands. He's got MRSA. He's got pneumonia. He's had a stroke. He's got brain bleed. I mean, you name it, he had it." And this guy was a 45-year-old guy that worked out, ran 5 miles a day, never had any prior medical history, and bam, now he's in the hospital on life support. And I stayed in touch with his stepdad while I was over there, and I believe the day we got back, he called me and said Josh had passed, unfortunately. To talk about a set of circumstances, so now Rob and I, within about 6 weeks, had lost 2 aviation whistleblowers, one complaining about Spirit and another complaining about Boeing. And we had others we were representing as well within the community, but those 2 were some of the more high profile, I think, because of the amount of media coverage that they had. So another one of those folks who's been in the media as well is a guy named Sam Mohawk. And he works on the 737 MAX quality program out in Renton, Washington. And he's actually a current employee. We filed an Air 21 on his behalf. He also raised some serious quality and safety issues. Coincidentally, like John, he alleged that there were thousands of lost non-conforming parts at the MAX plant there in Renton, which again is really disturbing. And we allege that he's been retaliated against for raising those things. He actually, complained also to the FAA, which ultimately substantiated all of the allegations that he had been raising internally. Sam's a great guy. I'm glad he's still a current employee there, and he's really trying to help get Boeing back on track and get their quality system back up and on track. All these events ultimately led to some congressional investigations, particularly with Senator Blumenthal's investigative committee. into Boeing and its safety culture. And just recently, the FAA fined Boeing $3.1 million, which is the maximum statutory penalty, apparently, and for not only having hundreds of what they found quality violations, but also they alleged that there was some undue pressure on some of the employees that shouldn't have existed. 3.1, I'm not sure what's going on with I haven't looked at the statutory penalty law with the FAA, but I think that needs to change. If $3.1 million is the most the agency can fine Boeing for hundreds of quality violations, I mean, $3.1 million is like 1/30th the price of one 737 MAX. I mean, to Boeing, that's like whatever. I mean, it's ridiculous, but doesn't really it doesn't really act as a deterrent. And that's what the agencies, I think, like the SEC, DOJ, they need to take really serious action against Boeing to act as a deterrent, so they don't continue the conduct that they've been engaging in, and that our clients allege that they have been engaging in. I'll say whistleblowers are folks that are honest. They have high integrity. They're not trying to get the limelight. They're trying to get the company to do the right thing, and that's why they come forward. They're brave folks that come forward and try to get the right thing done and to see that the right things happen. And we believe that our aviation whistleblowers actually have helped Boeing get back on track. It's going to be a long process, but we believe that they did help the company take a turn back towards the right direction. And we're hopeful that Boeing does finally get back on track, starts doing the right thing, listening to their employees that are raising concerns, not retaliate against their employees, actually enforce these strict anti-retaliation policies they have, and lift up whistleblowers and people that are complaining about quality issues. You're building airplanes. You're not building kitchen tables. You're putting everybody's life at risk that flies, and that should be taken very seriously as employees, as a whole of the company. And with that, I'll turn it over to my esteemed colleague, Rob Turkewitz.
Thank you, Brian. I'm Rob Turkewitz, as Brian mentioned, and Brian and I are co-counsel on a number of whistleblower cases and some other cases as well. We practice, we're separate firms, but we practice in the same building, which we bought and we fixed up. And Brian looks pretty big over there, but he's in real life, he's like 6'6". And when we bought and renovated a building, we had to raise the ceilings and raise all the door heights and everything else. So I want to thank Jackie and Whistleblowers of America and everything that she does. And I want to thank Tom and Government Accountability Project for everything that his organization does. And I want to thank you all, what you all do. I mean, it's crucial what you do. And I think it's really important for whistleblowers to really support each other and stick together. And, hopefully at some point things will change in this world. And, we were talking before about, what is it going to take to get people to come forward, and also people to accept people who come forward. And my thought is that businesses and government, we need to have a culture of transparency and accountability, and we need to push that. I think that I think that that could happen, but it's going to take all of us working together to do that. One of the things that I feel is common among whistleblowers is resilience. And I was reading last night a quote from Hemingway. I wrote it down here. Let's see. So Ernest Hemingway once said, "The hardest lesson I've had to learn as an adult is the relentless need to keep going, no matter how broken I feel inside. And that truth resonates deeply. It's getting up when all you want to do is hide. It's smiling through tears. It's showing up even when you feel completely worn out. Yet somehow we keep going. We keep moving forward, one step at a time, even when the path feels impossible. Resilience isn't always loud. Sometimes it's the quiet whisper that tells us, keep going. It's exhausting. It's unfair. But every small step is proof that we're still fighting. We're still here. And that's the bravest thing we can do." And when I read that, I thought about all the whistleblowers who are here today. I thought about John Barnett and our other clients. And it's inspiring. And you all inspire me. We talked about the 6 words that exemplify whistleblowing. And I think that Justice Louis Brandeis may have said it, where he said, sunlight is the best disinfectant. And that's what we all do. That's what we're bringing out. We're bringing problems to light. So just a little bit of background. I am a former Navy JAG attorney. And while I was on active duty, I also worked as a special assistant U.S. attorney and handled and prosecuted procurement fraud cases. And that opened up the door to me to whistleblower cases because in 1986, that was when the False Claims Act was amended and really opened the door for individuals to really have the incentive to come forward and had protections. And later on, they also inserted into the law retaliation protections. And so we already heard from Cleveland about the False Claims Act. I don't need to go into that. I think that what people don't know is just how many retaliation protection laws there are out there. And I have a slide, and if anybody wants a copy of it, I'm not going to go into too much detail, but Paul? Well, anyway.
There's your slide.
Here we go. Well, there's next. So go to the next one, please. Okay, so you can't really see it very well, but there are a large number of laws out there that cover a lot of different areas, from ground pollution, water pollution, asbestos, radiation, and we talked about the Air 21, which goes into, it makes it illegal to retaliate for aviation workers where there's a violation. So I think that the problem right now is that a lot of people don't know about these laws. And Tom and I have talked about it many times. It's important to get the word out so people know about it. What's even more important is for them to know that there is a very short statute of limitations for all these laws. And most of the time, when people are being retaliated against, it puts a mental strain, as you all know. And it takes a long time for people just to come out for fresh air, And by then, a lot of the statutes have already run. In fact, most of them will have run because they're between 30 days and 180 days. Air 21 is 90 days. So if you don't know that this law is out there to protect you from retaliation, you're not going to file in time. And that is your only remedy. There have been a number of decisions that these administrative laws are your only remedy. You can't sue in court for wrongful termination if you're within this law. So in Charleston, Boeing moved its 787 operation to Charleston, and there had been numerous cases filed against Boeing, but they were filed in federal district court, and every one of them were dismissed. And that says something about when you have that many cases being filed alleging retaliation. And of course, Boeing denies everything. I mean, they totally deny everything. So we were really lucky to have John Barnett call within the statute of limitations. And we were able to work with him in getting the case filed. And what also made a difference in this case is that John had thousands of documents that he downloaded. And in all these other cases that we've been involved with Boeing, we didn't have any documents, and Boeing just denied it. OSHA investigates it. They say there are no documents because it didn't happen. Well, they couldn't say that here. And we were fortunate. So Brian talked about John Barnett. I don't know how much I need to go into it, but John Barnett was probably one of the most decent, honest human beings I have ever met. And as Brian mentioned, our loss of John was devastating. It was devastating to us as lawyers because they don't train us as lawyers on how to deal with something like this. When you lose a client like that, and we lost 2 clients. And what we wanted to make sure was that it was fully investigated, and we worked with the family very closely and got to know the family. We knew them a little bit because John had won an award, the Callaway Award, shortly after he filed his complaint, and it was reported on by the New York Times. So the family came up, we all came up for the award ceremony. But his family is the most decent people, just down to earth from Louisiana. And John had the nickname Swampy. And the reason why he had the name Swampy was because he's from Louisiana. And he would do things as a manager, he would have dinners or bring in lunch for all his people. And it would include crawdaddies and things like that, and taught people about, the whole cuisine. He actually started a food truck at one point. So on the weekends, he would do a food truck serving Louisiana food. John also was a race car driver. He had there were so many different sides to him, but the most important thing to John was his integrity and the flying public, the safety of the flying public. And he basically would say that quality is the last line of defense for the safety of the flying public. And he took that very seriously, incredibly seriously. So as a manager, he would train his own people to follow these really strict rules that require you to document everything that's done on an airplane. You have to document the parts used, you have to document the work that was done. And what he was complaining about was that these things were not being fully documented. Brian mentioned lost parts. Parts are not supposed to go lost. Everything should be documented. When a part goes lost, I mean, you're talking hundreds of parts, it's a problem. So, John complained about all these things while he was there, and he was just generally retaliated against. I mean, he was given terrible fitness reports. Prior to this, before he came to Charleston, he was one of the top managers. He was probably the most knowledgeable people at Boeing about what the requirements were. I call them processes and procedures. And he knew he could just bang them out. And when something was not being done right, he spoke up. And he found himself constantly speaking up. So, in fact, they brought him to Charleston to set up the quality program with some other managers. He went out on the road and was hiring people for the quality program. So he was the kind of person where when he spoke up, people should be listening. And that's the problem we see with Boeing right now. Boeing was not listening to him and other people when they were speaking up. And that's the reason why just recently they got fined $3.1 million for the door blowout. They found hundreds of violations with that. So we feel, Brian and I at least feel that that Boeing is now listening. They've gone through a number of CEOs, and this CEO we feel is listening. And we're really hopeful that Boeing has turned a page and is now on the right track. We're also pleased that we've been able to resolve John Barnett's case. We're finalizing the terms and everything else of the settlements, but it's been a long haul for Brian and I. We've been litigating this thing for 7 years, and we owe a lot to Jackie, who's been incredibly helpful to us. John was suffering from PTSD, and he was having panic attacks and anxiety attacks. And Jackie was one of our experts in the case. And Tom has been incredibly helpful. Every time we had questions that we didn't know about the law, we turned to Tom. And Tom and his people were incredibly helpful. And that's what I mean about us all coming together and working with each other and helping each other. So, I mean, I could talk forever, I think, for hours about John Barnett, but I'm gonna go ahead and turn it over now, and if anyone has any questions.
I think we have a clip of John. Did you want to play that?
We put this video together as part of our trial, part of our case. We didn't go to trial because we were able to resolve the case within the last few months. So this is a video we put together, and it has some of John's interviews and some of his testimony. Actually, I'm not sure if we have testimony. There was his interviews and his life story.
Boeing was the place. I mean, they were the place to work, you know. And oh my God, it was amazing when I put that Boeing shirt on, how my chest puffed out. You know, I'd walk into the store around here and they're like, "Oh, you work for Boeing? That is awesome. And thank y'all so much. And you just mean so much to this area, you know."
Wow.
And it was just awesome. And it's just, we don't have that anymore here. Nobody does. I mean, everybody I talk to in Boeing, they're embarrassed to work there most of the time. It's just, it's gone. I'm originally from Louisiana. I'm a Louisiana boy. So when they opened up the Boeing, South Carolina plant, you know, I looked at it as a great opportunity, not only to get close to my family, but to, you know, help build it from the ground up. So I wanted to be a part of that, you know.
Was the culture of the factory in Charleston the same as the culture of the factory in Washington?
Oh, absolutely not. It's like night and day. They hired a lot of people from the South Carolina state that really had no experience with building airplanes and building commercial airplanes and understanding what procedures were and the criticality of them. So, you know, that was the big change, or the big difference I saw, is they just didn't have the experience down here.
So they are furiously trying to train all of these new workers, but they're really far behind on the 787 program, years behind.
Hello, my name is William Seitz. I was a Boeing employee for 36 years. I started in 1978, and in 2011, I transferred to Boeing Charleston, South Carolina, to open up the 787 production facility. While I was there, I met John Barnett, and he and I became close friends through our travels together for Boeing Charleston to do interviews to hire people to come work at our facility. John was a great guy to be with and work with. and we were of the same cloth, the same quality philosophy. John and I knew the processes and procedures for quality were meant to be followed, and it was becoming evident that production management wanted production over quality. And when we would raise quality issues, it became a hostile environment because they wanted the plane to keep moving, and they wanted us to essentially bypass our quality processes and procedures to allow production to be able to keep on their schedule, as opposed to putting quality in the foremost front of the process. Being a hostile environment eventually led to my leaving the facility because I could not change my outlook from the quality attitude that was instilled upon me from the first week of my employment at the Boeing company in 1978. John was the same way. He could not turn and look a different direction to allow production to basically run amok and overlook the quality of the processes and procedures that we needed, that we knew we needed to be in place to provide a quality aircraft for the public.
There are former employees from Boeing who say absolutely not. Some of them say they wouldn't put their own family members on one of these planes. And these are people who were in the factories where the planes were being put together. So what is it that they saw, and why do they feel that way? And should you be as concerned as they are? One of those former employees is John Barnett. He was a quality manager at Boeing and retired in 2017. But he was there as these planes were being manufactured. So joining us right now is John Barnett. Welcome to TMZ Live. Hi, John.
Hey, thanks for having me.
Thank you. So why don't we start with you telling us what your concerns are? The FAA is saying that the plane is now safe to fly. What do you say?
So I say, one, this is not a 737 problem. It's a Boeing problem. And I know the FAA's gone in and they've done due diligence and inspections to assure that the door plugs of the 737 are installed properly and the fasteners are torqued properly. But my concern is, what's the rest of the airplane? What's the rest of the condition of the airplane? And the reason my concern for that is, back in 2012, Boeing started removing inspection operations off their jobs. So it left the mechanics to buy off their own work. And
a lot of those inspections included verification that fasteners were torqued and that type of thing. So what we're seeing with the door plug blowout is what I've seen with the rest of the airplane, as far as jobs not being completed properly, inspection of steps being removed, issues being ignored.
Well, that is alarming. So you're not saying that it's specific to the 737. You're saying the 37, the 47, the 57, the 67, the 77, and the 87. Do you have the same concerns with them?
So no, I would cut you off there a little bit. I would say my concerns are with the 737 and the 787, because those programs have really embraced the theory that quality is overhead and non-value added. So those two programs have really put a strong effort into removing quality from the process.
So, John, after the Alaska Airlines near disaster, the CEO of Boeing came out and I believe the quote was, he said, told employees we had a quality escape happen here and told employees this can never happen again. Have there been actual cultural changes that should make passengers feel better about the quality of the planes that Boeing is cranking out?
I would say there was definitely a cultural change, but not for the better. When I saw Dave Cowlin step up and say, quality is our top priority, it made my stomach turn. It's like, quality hadn't been y'all's top priority for 20 years. All you've done is focused on getting rid of it, and then he goes on to say, we're going to get to the root cause. And my put is the executives and the leadership need to look in the mirror first thing to find root cause.
Did you ever expect to feel the way that you feel about the company now?
Oh, absolutely not. Natalie, I still lose sleep every night. I guess, I don't know, I got a conscience or something, I don't know, but I just, I have to get it addressed. That's why I keep telling my story. Somebody's got to step in and get it addressed.
Part of Swampy's job was to check the insides of planes to make sure that as workers are building the planes, nothing is left behind. No debris is left inside the aircraft.
So I was called out to the airplane to look at an issue, and that's where we discovered all this debris, these 3-inch long titanium slivers laying around. It's just debris everywhere.
And while he's doing these inspections, he begins to notice that there are clusters of metal slivers that are hanging over the wires that control the plane.
The risk here is these metal slivers will migrate into power panel, any kind of power, any kind of electronic equipment, and short it out and cause a fire. And if it's at 40,000 feet, that's a problem.
Is this normal?
No, absolutely not.
Remember that in this factory, there is a huge amount of pressure to produce these planes as fast as possible. And if you don't have the part that you need to finish the job, just one job on the airplane, that holds you back. That holds the whole production line back. And so if it's easier and faster to just go grab a defective part and put it on the plane, that might be what you do in that scenario.
In fact, I had one senior manager one day tell me that actually there was a few of us standing around talking about inspection, and he said, we don't need inspectors. These planes are too smart to fall out of the sky. It's like, oh my God.
Do we want to take a break there? I mean, that's, I think it was just valuable to hear John in his own words. I want to give us time for questions, and then we're going to go into lunch and the Giraffe Awards. So I would really ask Nobody leave, because we have awardees we really want to honor, and some of them are going to be surprised by their award, so don't leave. Questions for the attorneys?
So I can talk loud.
Okay.
For a long time. So with regards to the key 10 lawsuits you were talking about, you said that if you file a key 10 lawsuit, they put under seal the Attorney General, who clearly does not want to do her job at all in Delaware. That's very clear. But you said that if I were to go ahead and litigate it myself, which I'm perfectly able to do, but I'm not an attorney, you said you have to have an attorney? Is that in state court or is that in federal court? Because these are both state and federal crimes.
Yeah, the prevailing view is that in order, you can be a pro se representative for yourself, but when you're standing in the shoes of the government, you have to be represented by counsel. So courts will typically tell whistleblowers, they're called relators in the False Claims Act context, that if they're unrepresented, they have a certain amount of time to find counsel, or they're subject to having the case dismissed, sua sponte by the court. It's not even a False Claims Act specific rule.
And I was going to ask you about, you mentioned the First Amendment. What's happening now with people, especially some federal employees who are writing dissent letters or going on social media and saying things about either their employer or the government or whatever? How are they protected or not protected by the First Amendment to say, whatever their beliefs are?
This is definitely more in Tom's bailiwick than mine. But I think in some of these contexts, the questions of First Amendment protections have a lot to do with where and how the person is expressing themselves. So if it's someone whose job is to report certain things to the state, and they're reporting those things through those sort of job-oriented channels, that may not be seen as speech. That may be seen as work. I think that where people are posting things to social media, they're certainly talking more as a citizen and less as an employee. And so I would think that First Amendment protections would be more obvious in those contexts. Now, the question of proving whether an adverse action is politically motivated is a different question, but I think the protections are there. Tom?
Well, Jackie, there's no social media exception for the First Amendment, but it is on paper weaker than the whistleblower rights. The whistleblower rights say if you're disclosing credible information of a significant abuse of power, it's protected activity. It's illegal to retaliate against you. Under the First Amendment, you have to pass a couple of more difficult tests. One is you have to show that it's a matter of public concern, and that's pretty subjective and pretty vague. So you're at the mercy of the biases of the judge. The second test that you have to pass is that the benefits to the public outweigh the disadvantage of disrupting the government agency. And that one's a whole can of worms that can go in any different direction. And then the burdens of proof are tougher. Once you've won those two battles, you just to have a prima facie case, just a basic case to be considered further. You have to show that that First Amendment speech was the primary motivating factor for what happened to you. And that really involves reading the employer's mind, and they're not going to, unless they're really slow, they're not going to say, I did this to retaliate. They're going to say, oh, no, it's for a pretext. And then if you win that battle, they only have to prove by a preponderance of the evidence, 50% plus, they would have done the same thing for an independent reason. And they control access to all the witnesses, all the records. It's not a fair fight. So there's no loophole, but First Amendment cases are really hard.
That's why I called Tom the first question.
Yeah. One of the things that I think we're seeing also is that, as Tom was describing before, what's being set up now in government is a deep state. And the deep state is a state where if you say anything that is against the party in power, you're going to get fired. So I think I think there's First Amendment rights, and they are not being protected.
I'll give you some examples of how the speech can be detected, which has really shocked me. So when I started the Civilian Reprisal Investigations Directorate in the Defense Department's Inspector General Office, the General Counsel had the IT team search all of the computers in our building because there had been a Washington Post article regarding whistleblowing. And the general counsel wanted to know the name of every employee. This was like 2 weeks after I took over the job to create a whistleblower protection program. Like, are you asking for this fight? And so he wanted to know the names of all the individuals who had just read or pulled down the article. This wasn't a leak investigation. This was just to see who had read the article, because that was going to be his list of who to watch. So we had to elevate it to the IG, Inspector General Joe Schmitz, who I really liked as an IG. Some people had some problems with Joe, but I thought he had some right instincts. And we got that situation corrected. But you could only do that inside what we call the paperclip, our building in Crystal City. So advance the bucket a little further. I represented, I'm not ashamed of it, some of the January 6th defendants. Okay, I'm an employment law firm. We got lots of FBI contacts, and there were a lot of people in deep trouble with January 6th. So this is like 20 years after the scanning of the article incident at the Inspector General's office. I was shocked at the monitoring ability that the FBI had of its own employees, that you could go to Google. That thing you're carrying is a tracker, folks. That data exists, and you can get that data. I had seen it used in very discrete security investigations for a particular building, but I never imagined that you could do basically analysis of a large group, thousands of people, and figure out where they were in 10-minute increments. You got to remember the Google data, there's an offset problem, about 50 yards. So you could have been 50 yards this way or 50 yards that way. But the ability to track what ATMs people are used. Oh, we know you were in Washington because you use the ATM. The Banking Act allowed them to get the records. They don't even have to have a search warrant. Just send a letter. And they know exactly where you're getting. My husband does that every day. If I use my credit card, a little ka-ching goes off on his laptop, and he can see exactly what Dan is spending as he goes all across Washington, D.C. He'll count the calories for me as well. So that you see where it leapfrogged at that point. Now, because of AI and because so many of these processes are being centralized, you don't have to even be within a particular agency. We're not quite there, but we're pretty close, where you can run a dragnet, say put a reporter's name into the system, and you can pull everybody who had contact with that reporter over the last 18 months. So if you want to take a reporter out, go after their network, right? So all the conventions that existed post-Watergate are now coming to a close. And I don't want to, rain on the proceeding today, but the Great Society is we're in the sunset. We don't know what it's going to be, the next thing, the Greater America or the New America, what it happens to be, but we'll be there in about 10 years. And I think for Jeff Rook used to have this point after the Huffman case came down. Jeff was my boss at Peer, and he didn't focus on Huffman when it first came out, and he couldn't figure out why I couldn't figure out the cases. And he just, I said, I took the case in, I said, this came out last year. And he read it and he said, well, this is BS. I said, yes, Jeff, I agree, it's BS. And I don't think Judge Dyke meant to write something that was so restrictive of whistleblowing. Maybe he did. Tom fixed it, by the way, with the WPA in 2012. But when Huffman came out, it changed the rules. And we're in that kind of movement now where the rules have changed. And I really fear at some point we're going to have to go back, as Jeff thought in 2000 when Huffman came out. You're going to go back to Mark Felt in the parking garage, talking to Robert Redford or whoever he played, Woodward or Bernstein, whoever happened to be, and having those conversations in a way that is not trackable. Okay, so we are back to the future. We may be getting to a point where those sources are kept secret for generations after they have the actual sourcing happen, because we could end up with the Moloch type report and the environment where people are pursued and gone after because of loyalty issues. And that really is. So the challenge with the First Amendment is that it's nice in the abstract. It's very difficult to actually win with that, and it's very expensive. And that's trying to find a system where you've got something that's economical for the whistleblower to get vindication is the hard part.
No, I appreciate that. We just have, that question comes up. I said what I said on social media on my private account, and now I'm being harassed at work for what I said. And so that's why I was very interested in that. I know I think we have some hand raises online. So if we can maybe unmute some of those and then let some of the people who have been logged in, I know there's a bunch of them that have been watching us.
I've got the number 1 next to me. Am I online? Ready?
Sure. Yep.
Okay. The question has to deal with admissible data. Oh,
he can't see you.
Oh, sure. Oop, there.
Can you introduce yourself?
Okay. Mike Welch. I was a VA whistleblower.
Hey, Mike.
Hi. And one has to do with basically 2 questions. Admissibility of information. I had multiple retaliations over years, and because the whistleblowing process was unresponsive, I went many things for grievance procedures, which includes them falsifying performance reports, giving derogatory false reports by falsifying my performance and such. And I won every single grievance against me. I mean, every single grievance I submitted, but they said that was inadmissible as evidence as part of an ongoing retaliation issue under the whistleblower process, because a grievance resolves an issue. So that was one issue, whether that was truth or not. And the other was when I had cases submitted, I submitted 5 cases to the VA whistleblower office, as well as multiple IG cases, and the VA found in favor of the VA, basically supervisors, that the action was taken for cause without me ever being given any of the data on why they found that way. And then the Office of Special Counsel case was also closed because they had gotten a letter from VA saying it was for cause, and it wasn't until we reached the Merit Review Board case under discovery that I was finally provided the information that showed that VA had falsified documents and submitted, so they closed everything up until the case, and I was never provided any of the data on why they closed the cases. So what's the requirements for them to provide feedback information on case closures as a rule?
All right. Well, Tom, can you answer the question about the grievances?
Yeah, and the OSC transparency. There's no evidentiary loophole for submitting evidence from a grievance. I think what might have happened there is if it was being presented as part of a retaliatory investigation, you have to wait for the personnel action to be taken before the retaliatory investigation kicks in your rights. That might be the answer. As far as
closing cases without giving
closing cases without information. The Office of Special Counsel is extremely mole-like, and they don't want anybody to know the background for their decisions. And we've fought them in court on Freedom of Information Act, and the courts have upheld the secrecy. We did get into the 2012, it was the 2012 law, Whistleblower Protection Enhancement Act, that they have to provide you with a statement that when they close the case, summary of your facts, their conclusions of law, and their findings about those facts. And they are fairly conscientious about that. They at least know, why they did it. But it's certainly not complete. And it's nothing like if you went to court and had due process and the judge had to explain and defend the findings and the rulings. They're usually like a 2 or 3 page letter tops.
Okay, Dan?
Mr. Welch, I want to apologize to you because I was the one who suggested to the nominee for special counsel that they focus on VA cases just prior to your case going through. What I did not anticipate was that there would be the relationship with the VAIG, which I did not think was a mature enough office at the time to handle the cases. I had been called in by Senator Grassley several times as sort of an expert to advise various agencies on their whistleblower protection procedures. And so I had an idea across the 72 odd IGs who could handle it and who could not. And I never thought the VA was in a position maturity wise to do what they were being asked to do during that time period. The challenge we had, and this shows how difficult it is, when I took over as the ICWASP, the Intelligence Community Whistleblowing and Source Protection Program. It was an unfortunate acronym because WASP is also, you're thinking of like some starchy guy up in New Haven, Connecticut, but WASP is also the acronym for the Cuban Intelligence Service. So ICWASP did not go over well with Langley, but the hardest thing that Mr. McCullough and I had to achieve was to get these IGs to give us their investigations. We're not talking about the whistleblower. We're talking about the IG who's in charge of the IC whistleblowing program. We could not get the files out of the IGs. It was a 5-year battle. And part of the reason why I left in the untimely manner I left was that once this got going, the IG staff loved the program so much they started filing complaints against the IGs. And so you saw a whole series of IGs go down 2015 to 2018 in whistleblower investigations because their own staff were basically filing complaints against them. So getting the centralization of the data cut across so many agencies' interests that it was in my case with IC whistleblowing, they just took the program out. And that was what I was working on right before I left. I was looking at technology in a way that what I wanted to have was the director of national intelligence be able to go to a room, sit down in a chair like Captain James Tiberius Kirk, and have up on the screen real-time data of all the complaints coming in to their hotlines so that somebody could brief, at that time, Director Clapper, and say, sex is up, fraud is down, we have more DUIs, whatever that happens to be. Prostitution, which is actually up right now in security clearance fields. So all those things you could then sift and collate, and then you could start addressing the ills of the community with the data that you're collecting. I also tried to do this at the Defense Department with something called DCATS, which is still around over there. But the problem is once you get to that level of transparency and candor, which is not to the complainant and not to the American people, we're just talking about the elite knowing what the elite is doing. Well, the president, who's trying to run a department or a branch that really has no control 320 yards outside his office, the response was absolute revulsion. They just did not want to share the data. So, Mike, my apologies you had to go through that. I feel somewhat responsible for your tribulations.
And I think we had another question online, and then we'll end up with in the room. Oh, unmiked.
Kathy, if you would raise your hand, just so I know that you still have a question, and then give me a second to unmute you. Oh, she's good. You are good. Go ahead.
Okay, I want to go with this one question. Now, since somebody mentioned earlier about the ability to go to court for whistleblowers, now I come mainly from discrimination law and bullying, and the problem is with all of those, people who have to go to an attorney, especially whistleblowers, are going to be suffering financially. It's going to destroy their lives. Just that from that. There's got to be some way to have, after we go through this current constitutional crisis in Supreme Court, there has to be a way to set up an administrative process that insulates it from politics, from money, so that whistleblowers don't have to lose everything. What do you think?
Well, we certainly agree with you. We were on the Hill yesterday, and we've had a proposal. I think some of you heard me talk about this, that we've, oh, he wants me to move over, that we've had a proposal on the Hill with an office of the Whistleblower Protection Advocate, so that whistleblowers can have their cases supported and funded like the Office of Victims of Crime does for other types of victims who have been sexually assaulted or human trafficked, but we don't have the same kind of office, or we're not using the money that whistleblowers help recover, which is like $2.2 billion, I think, at this point. That money goes into the OVC fund, but it does not go to a whistleblower program. And that's been something for the last 2 years now that WoA has asked Congress to at least try to create a proposal for. So I think it's a really good question.
Kathy, this is Dan again. I don't mean to be a ball hog here, but this is a really great idea that you've raised, and Jackie has reinforced. When the Civilian Reprisal Investigations Directorate was set up in the Defense Department in 2003, the original position description had me being able to go to MSPB on behalf of defense whistleblowers. So like a special prosecutor. That's why I took the job. I said, oh, this is where I can learn how to, I'm going to go in and I'm going to screw management to the wall. And when I landed in the position, the general counsel at that time, was actually the assistant deputy general counsel, read the position description, and a battle broke out because there was no way our general counsel wanted to have a GS-15 going in before the Merit Systems Protection Board on behalf of Defense Department whistleblowers. That battle continued I was there for 12 years. It continued all 12 years. And my biggest lesson learned, and this is going to be the biggest obstacle to getting this for employees, is that our agency attorneys, there are some good agency attorneys, there are some, but our agency attorneys are attorneys for management. They're for the leadership. And the rude awakening for many people is to understand that they are unregulated. Why are they unregulated? If you're the head of an agency, if you're the inspector general of the Defense Department, and your general counsel does something that you want to discipline him for, your bar regulatory authority is a state. What federal agency head is going to give a disciplinary matter regarding his agency's operations to the Superior Court of Massachusetts. So you have a whole cadre of attorneys out there who are effectively unregulated. They are effectively unregulated. They can do as they please, and they do. And I watched this for like 8 years, and then finally I was Mr. McCullough's rep to the Transparency Committee over at the White House. So they met up at the archives. I got in at like tranche number 4 on that, and I actually got to sit across the table from the DOJ and the OPM attorneys who were very senior at that point. They were in their late 60s, who admitted to me that they had been single-handedly shutting down whistleblower reform efforts since they were 20-year-olds. This was my deep state moment where I realized that there were like 3 attorneys between OPM and DOJ who involved in personnel law, who every time something came up that would help the whistleblowers, they were just crushing it, absolutely crushing it. So finally I got an issue. And it was taken to Senator Grassley. And through Senator Grassley's support, we were able to get a third party, I won't say who it was, determined in an investigation that a general counsel had committed malpractice. And I was like, wow, this is going to be the moment. This is the Ellsberg moment. Oh, we got it. We got it. The question is, where do you send it? And at that point, the head of the agency flinched. And you know, he could have sent it at that point to the bar authority. He didn't want